We'll talk about that. You're just talking about scheduling right now. Okay.
Okay, yes,
Okay.
Hey, Mr. Davis, give me 1 second.
yes, sir.
Do you have the indictment number? I just tried looking it up.
It's,
I don't have the trial calendar with me.
I just,
How do you spell your first name?
Demit.
Oh, I got the wrong first name. So DEM.
It's Demetris.
Oh, Demetrius.
it's spelled wrong in
Oh.
Odyssey though, Judge. So the case number is 24SC
Ah,
006492-01.
okay. Got it. You're right. It is spelled differently. Okay. Mr. Davis, you have been re-indicted. You've got the original charges, and then I know Ms. Wood had told you there was a new set of charges kind of floating around out there. The state just combined them all in one indictment. But because there's a new indictment, it's pretty similar to the old one, but it still is new. We just need to do your arraignment all over again.
Yes, sir.
And so Ms. Wood can waive arraignment on your behalf where she enters a not guilty plea, or we can do a formal arraignment where I read each charge into the record. And we're going to follow Ms. Wood's guidance on this as to what we're going to do. And then we're keeping your case on the trial calendar in case it's something that can work out. But Ms. Wood will let me know if she's already filed a motion to sever the counts because they're two different sets of allegations. And so her perspective as the legal expert on your team is that if you do go to trial, you should be tried for one set and then whatever happens with that one, be tried for the other set of allegations and not mush them all together. We'll have a hearing on that. But in the meantime, I just need to know if we're good to go forward with the indictment. And like I said, we'll keep your case on the trial calendar and see what happens with this motion and all that kind of stuff. Okay?
Yes, sir.
Ms. Wood, is Mr. Davis waiving arraignment?
Yes, Judge. I filed the waiver yesterday.
Okay, then we're all set, Mr. Davis. Ms. Wood will continue working with you. I know she's working very hard on your behalf to try to resolve the case short of trial.
Yes, sir.
She shared with me that it's not a particularly strong trial for you in terms of the evidence. In other words, the state has strong evidence. But I also know the stakes are very high. The state's not offering you probation. It's a pretty serious outcome for you, no matter how it goes, whether you go to trial, if it doesn't end well, or if you enter a plea. But Ms. Wood is moving forward with that. And I'll have you brought back here if there's some breakthrough and things are resolved. Otherwise, I know you are on a trial calendar that starts next Monday, but you're not on the first week of that trial calendar. The earliest you would go would be that second week, the week of the 18th. But it's not my calendar exclusively. It has cases from a bunch of judges. And so I wait in line until my case could go, but your case is my case on that calendar. And Ms. Wood knows that, and she'll be ready to go if it gets reached. But I also have a calendar here, so Ms. Wood will be juggling those two things, and she'll let you know what's happening. Any questions about process?
I want, not really. I wanted to, know, do I still, when I come back, you said Monday?
So you will not be brought over next Monday. You might be brought over on the 18th if you make it onto the short list of cases for that second week of trial that your case is on.
So we will be going to trial?
Don't know. You may. There'll be no surprises. Ms. Wood's going to let you know. You're not going to walk in here and there are going to be jurors sitting there. Ms. Wood will let you know. If you do go to trial, we'll get you a different set of clothes, all that kind of stuff. So I don't want you to panic. But if you are brought over on the 18th, that's a sign that you're on the short list for that week. Okay?
Okay. I
So
don't
we'll
want to
keep
go.
talking, okay?
Okay, yes, ma'am.
All right. Thank you.
All right. Thank you both. All right. And you had someone for whom we're just doing the
Yes, Mr. Stafford, which is position number 6.
Mr. Stafford, come on up with your security vest.
And Judge, I have an updated offer on Mr. Jackson, so I'll step out after this and call him.
Okay. All right. Let's get on the record in position 6, which is State versus Stafford, 25 SC 000644. Mr. Stafford, you are charged with burglary in the first degree in this case. Ms. Wood, do you have what you believe is all the discovery in the case?
I think I may be missing a couple of things if it exists at this point.
Okay. What kinds of things would those be?
A possible recorded conversation between the alleged victim and Mr. Stafford.
Okay.
Possible surveillance footage. It sounds like it could be from like a Ring security camera. And then receipts, if there are any, from the alleged damage.
Got it. The alleged victim is male or female?
Female.
Female, Ms. Reeves. So it sounds like the things you described aren't necessarily, I mean, they're certainly not police-generated things. So if the state has them, they got them from Ms. Reeves or whatever, certainly things you'd be entitled to if they're in the state's custody. Okay. It's interesting, there's a date range for the allegation. Okay. What is the state's offer, Ms. Davis, if Mr. Stafford were to go forward with a plea today?
The state's offer would be for 7 years, for him to serve. I want to say Mr. Stafford has served quite a bit of time in custody. It was about 277 days. So credit for all that time, the balance on probation, 40 hours community service, anger management, no contact with the victim, Ms. Reeves, and just to stay away from the location. So we're not at this time requesting any restitution. It would just primarily be community service and anger management, and to have no contact with the victim or go to her residence.
Okay. So I'm going to round it to around 9 months that he served in custody. So it would be 7 years to serve 9 months balance probated,
Yes, Judge?
plus those conditions.
Yes.
Okay. Mr. Stafford, do you understand what the state's recommending? If you were to enter a plea today, the state would recommend what is in effect a probated sentence. You'd not go back into custody. Your sentence would reflect that you were in custody for about 9 months.
I was in custody 21 months.
He was revoked on the basis of this case, Judge, and he did some time with the Department of Corrections.
Interesting. Revoked for a case out of Fulton?
Yes,
Who revoked you?
Dunaway, I believe.
Dunaway, yeah, Judge Eric Dunaway.
Okay. All right. You serve whatever time you served. We'll structure it to reflect all that, but you then be on probation. Bottom line is the state's recommendation is effectively probation. You understand that?
Yeah,
Yes?
I understand.
Okay. You understand that today, if you entered a plea, you could withdraw that plea if the sentence I gave you was more than what Ms. Wood asked for on your behalf.
Yeah, I'm not gonna enter a plea today though.
Okay, well, you don't have to. I just want to make sure you understand these things so that when we're together on September 25th, you don't say, wait a minute, now they're offering me 2 years to serve. I want that deal back in August, because that's their offer today. It may not be their offer tomorrow. It may get better. They may say, how about a misdemeanor? You could say yes or no to that. You always have the right to go to trial. You're not waiving that unless you enter a plea. So that's what we're teeing this up for then, would be a trial on that September trial calendar. If you decide to enter a plea sometime after today, you can do that, but you are, after today, losing that right to be able to withdraw from the plea if you don't like the sentence you get.
Yes,
Okay? Any questions about that?
No, sir.
Where do you work security?
At First Place Hotel on Snapfingerwood.
Is it not a real safe hotel?
It's okay. I mean, ain't nothing happened since we've been working out there.
Who's we?
Me and all my brothers.
Okay. You're like the security detail at the hotel?
Yeah, all of us, yeah.
How did they hire all of your brothers at once?
The man who owned the security company, his twin brother is in the same prison with my dad, and that's how we found out about the
Okay,
job.
so you guys are connected in that way.
Mhm.
Interesting. How many hours do you work there?
We work about 10 hours, 5 days a week.
Okay. Meaning you work 50 hours a week or you
Yeah.
work 2 hours a day?
Now we work 50 hours a week.
It's a lot of security. Okay. Any questions about anything?
No, sir.
Let me check your bond and we'll go from there. I guess, Ms. Wood, who are you? Are you bugging Ms. Davis for this discovery, or are you hoping that Ms. Reeves is handing over that discovery?
I have not spoken to Ms. Reeves yet, but I've been bugging Ms. Davis.
Okay.
We'll keep working on it.
I didn't realize this. Okay, from back there, bond. All right, you're supposed to stay away from the address on Hapeville Road and stay away from Ms. Reeves. You're able to keep doing that?
Yes, sir.
Okay, then you're all set. I will see you on September 25th. Did you get something in the mail telling you to be here?
Yes, sir.
All right, that address is still good?
Yes, sir.
All right, we'll see you on September 25th.
All right, thank you.
You're welcome. All right, let's get Mr. Murph up here, please.
Thank you.
And you can call Mr.
Time to break this one down. We had a trio of cases roll through Judge McBurney's courtroom, each one bringing its own tone, pace, and flavor. Let's start with Demetrius Davis, who appeared for a procedural check-in following his reindictment. The judge opened with an acknowledgement that Mr. Davis's name had been misspelled in the system. Not exactly a strong omen, but the bigger point was this. The charges were consolidated into a new indictment, and defense attorney Miss Wood had already filed a motion to sever the counts. The judge emphasized that the state's evidence appeared strong and that the stakes were high, with no probation on the table. Mr. Davis was calm, a little anxious about scheduling, but respectful and engaged. The courtroom atmosphere here was low-key and focused on logistics. No fireworks, just careful pretrial groundwork. Judge McBurney handled it with his trademark balance, transparent about risk, but clear that the defense had options. He also made sure Mr. Davis understood exactly where things stood on the trial calendar and when he might be brought back. No surprises, no gotchas. Next up was Mr. Stafford, who appeared wearing a security vest, which, while not unusual for in-custody appearances, added a visual reminder that this wasn't traffic court. He's charged with burglary in the first degree, and the discussion centered around discovery and a potential plea deal. Miss Wood flagged a few missing pieces, possibly a ring camera video, a phone conversation between the victim and Stafford, and some receipts, but nothing that derailed the discussion. Miss Davis, for the state, offered 7 years with 9 months to serve, credit for time already spent in custody, and the balance on probation, along with anger management, community service, and a no-contact order with the victim. Mr. Stafford, for his part, declined the offer for now but understood it clearly and responded with a polite, "Not gonna enter plea today, though." His demeanor was respectful and steady. The court made sure he understood that the current offer might not be available later. Then came the curveball. Stafford mentioned that he works hotel security with his brothers, all hired through a family connection involving their father and the security company owner's twin brother currently incarcerated. You can't make this stuff up, but again, Judge McBurney handled it like a pro. Light chuckle, no judgment, just moving right along. Finally, there was a brief administrative step involving Mr. Pruley Murph and an upcoming update from Mr. Jackson. Nothing substantive there, just routine courtroom flow. Overall, the courtroom tone was organized, professional, and even a bit conversational. There were no outbursts, no dramatics, just a steady judicial rhythm with the occasional moment of levity. Judge McBurney remained his usual composed self, giving defendants space to speak, but always keeping the train on the rails. And shout out to Miss Wood, she was juggling multiple clients and issues and still keeping things crisp and clear. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.